Are you a Minnesota farmland owner with farmland value of more than $3 million? Do you know about this special deduction that can allow us to pull back up to $2 million off of your estate and save your kids significant estate tax savings here in Minnesota? If you don't, watch this video to learn more. I'm Jason Wagner, the farm lawyer. I work with family farmers every single day to help them pass the farm on to the next generation. Today we're talking about a very important deduction. It's called the Family Farm Land Deduction. So this deduction allows us to deduct up to $2 million off of the value of the estate as long as we meet certain requirements. And family business owners, there's a deduction for you too. It's called the Family Business Deduction. I'm not going to talk about that in this video, but you should know that you can also qualify for up to a $2 million family business deduction on the estate tax return. So let's set the landscape. Everybody here in Minnesota, you, me, your neighbor, your friends, your mom, your uncle, whoever, so they're Minnesota residents, they have a $3 million Minnesota exemption, okay? Your spouse also has a $3 million exemption, which is important, and I'll talk about later. So everybody has that $3 million exemption without even trying. Farmers, you may get an extra $2 million if you meet the requirements and you have the right mix of assets. Let's take a person that has a farm that's valued at $5 million. We're going to say that's the net estate value. In other words, they don't have any debt on it. There's no liens. This is what it was appraised at as of the date of death, $5 million. So as I said, we get to take our $3 million off. Everybody does. So now I have $2 million of excess. That's going to be taxed at my estate. Okay. It's a 13% rate at the first rate in Minnesota. It tops out at 16%, but here we'd be at a 13% rate. So that's a $260,000 tax that my kids or whoever this property goes to would pay upon my passing. Now, let's say I have 5 kids. They each receive $1 million if I divided it equally, which you should never do, of course, if you're leaving it to your farming area. That'd be stupid. Watch my other videos to learn why. But does that mean that because each child only received $1 million, they don't have to pay an estate tax? Absolutely not. That would be an inheritance tax. This is an estate tax. An estate tax is a tax on the value of your estate when you die. So we have to look at everything you owned, put an appraisal on it, put a date of death value on it. Doesn't matter if it's going to 10 people or 100 people. We look at the value as of the time of death. The only person that we do care about, I should say there are two people we do care about. One would be your spouse. So if you leave it to your husband or wife, you do not have to pay an estate tax for leaving assets to your spouse. There's a full deduction for that. The other is charity. You know, if you leave your farm to a charity, again, you're not going to pay estate tax. There's a dollar for dollar charitable deduction. Everybody else in the world would potentially trigger an estate tax based on a $5 million valuation. So how can I unlock this additional $2 million of protection? The property would have to qualify as family farmland property in order to do that. So what are the requirements? Well, first, it has to be ag homestead on the property tax statement in the year of death. That means that we're going to pull the property tax statement. We're going to look at it. We're going to check the classification. If the classification says non-homestead, we're done. We're probably not going to qualify unless there was some administrative error that hopefully we can fix. But we want to see ag homestead right there on that tax statement, which is why it's so important. Check out my other videos for making sure that you do qualify your land as ag homestead, even though you may no longer be getting a property tax deduction from year to year. We want that land to be ag homestead in the year of death. So if you haven't classified it as ag homestead and it's eligible, get that done now. So if I'm living on the farm or I'm actively engaged in farming, and as long as I live close enough to the farm within 4 cities or townships, it's going to be classified as ag homestead or eligible for ag homestead. Next, I have to have owned that land for at least 3 years prior to my death. That means that if I bought the neighbor's farm a year before I died and connected it to my farm, and even though it's all ag homestead, if I didn't own it for at least 3 years, that property is not going to be eligible for this deduction. My other land might be, or still could be, but that piece itself would not be. Another requirement, if I own that land through an LLC or a corporation or some other entity that's regulated by Minnesota's corporate farm law, I need to be in compliance. I need to have an updated report with the state of Minnesota Department of Ag that shows that I am a family farm, that I am not in violation of Minnesota's corporate farm law. If I've met those requirements before I died, it's ag homestead in the year of death, I've owned it for at least 3 years prior to death, and I'm either not subject to or in compliance with Minnesota's corporate farm law, now I am eligible to deduct this on my estate tax return. But there's more. There are things that have to happen after death in order for this deduction to stay viable. So first, it has to go to qualified heirs. Most often, this is going to be your kids. So if I leave this farm to my kids, they're qualified heirs. Okay, I've met that requirement. Do my qualified heirs need to farm it? No. That is a misconception. It's an earlier version of the law. My qualified heirs do not have to farm the land. Okay. Do my qualified heirs need to keep it as ag homestead? No, they do not. But that does bring us to another important requirement, is that they have to keep it as farmland. We don't care if it's ag homestead after death. Probably, unless they're farming it or living there, it's not going to be. We do care that it's going to stay as farmland after death, though. Finally, the kids have to agree that they will not sell the land for at least 3 years after I'm gone. So we said we had to own it for at least 3 years prior to death. We also have to own it for at least 3 years after death. Does this mean the kids can't sell it between themselves? Nope, they can. They can sell it between themselves. That's not a problem. We just can't have them selling it to the neighbor or putting it on auction and selling it to whoever or developing it. They would not be allowed to deduct the property at that point. Take my $5 million farm. As I said, I get a $3 million exemption. That leaves $2 million left. I'm going to use my family farmland deduction. My kids are going to say, yes, we will agree we won't sell it for at least 3 years. Now I get an extra $2 million to pull off. My $5 million farm has now passed through my Minnesota taxable estate without incurring an estate tax. Very important deduction. Very important that you know this, especially if you're planning on that farm continuing to the next generation. Now, as I said earlier, if I leave this to my spouse, there's no tax. But I also have not used any of my $3 million exemption, and I have not used any of my $2 million deduction. So maybe I don't want to leave it in my spouse. Maybe I want to leave that in my trust and allow my spouse to get the income off of it. That way I can use my $3 million exemption and my $2 million deduction. I've protected $5 million in my estate by doing that. If I have a $10 million farm and 5's in my name and 5's in my spouse's name, and they do the exact same thing that I just did at their passing, they can still use their $3 million exemption and their $2 million deduction. So that means that I could effectively, if I have enough farmland and I meet all the requirements, protect up to $10 million of farmland in my Minnesota estate through good estate planning and working with a farm lawyer. For more farm law tips, subscribe, follow me on Facebook, and drop a comment below.